The CO 273, which comes to be issued on 6th August, is in a sense applied in anticipation. The bill for reorganization is presented by the President, tabled in the Rajya Sabha, passed by Rajya Sabha on the 5th of August, then tabled in Lok Sabha on 6th of August, and simultaneously with the recommendation of Lok Sabha to the President to issue CO 273, but simultaneously, even before 273 has been issued, Lok Sabha passes a bill which is purportedly passed by the Rajya Sabha the previous day. So what happens ultimately?
The justice said, what is the proposition? Then they have tailored and managed the time in a manner, everything occurred within this 2 days' time. But we wanted to know, what is that you are saying?
The point is that the provisos which are in place and the explanations, the two explanations which are in Article 3, the two explanations were not applicable in Jammu and Kashmir because the 18th Amendment was never extended to Jammu and Kashmir. So the explanation which said that it's a union territory, the argument is that we can interchange states and union territories under Article 3 because of the two explanations which were introduced by the 18th Amendment. That was not applicable to Jammu and Kashmir on the 5th of August. So as far as Jammu and Kashmir is concerned on the 5th of August, it was only a state. Any changes under Article 3 could only be state to state. But I'll come to it, I'm just formulating the points. I'll hand across this. Now, dehouse this aspect, my submission is that Part 1, that is Articles 1, 2, 3 and 4, have to be read conjointly. And when you read them conjointly, no power can be found in Article 3 to convert a state into a union territory, notwithstanding the two explanations which are added by the 18th Amendment.
Yeah.
4 or 5, because I might lose track because it's all oral.
It's 4, right?
It was that if two interpretations were possible as far as Article 3 is concerned, then that reading should be preferred, which would be in keeping with the principles of federalism, the principles of democracy, the principles of the representation of the people of a state, and which would keep Article 3 out of conflict with Article 368. That reading should be preferred, and not a reading where Article 3 is allowed to ride roughshod, coach and horses through Article 368 without any of the safeguards introduced in 368. And this, Lord, I'll show your lordships that there has to be a harmonious construction between these articles, where that article 3 and 4, which allow an amendment to the Constitution but by a simple majority in Parliament, can't impinge on those amendments which have the effect of either which attract the proviso to 368 or which in any case require a special majority by their very nature.
Singh, will you be referring to the text of the Constitution for developing an argument? How should we now go about it? We made your 4 points. You made a note of the 4 points.
No, there is a little more here. And I believe that the Reorganization Act, apart from 370, is very, very important for the people of Jammu and Kashmir. And also that if this interpretation of Article 3 were to be upheld by your lordships, then this is the thin end of the wedge for democracy and federalism in the country as a whole. Because any party in power at the center, if it also happens to be the party in power in a given state, can just convert that state by a simple majority in the state legislature, and a simple majority in Parliament can convert the state into a union territory. This is a proposition, a course of action.
Let's see Article 3 now.
Which is fraught. I'll come back to Article 3 in a moment. First, I'll go see
yes,
the same
certainly.
sequence. I'm sorry?
The word used over here is suspended.
Suspended, that's right.
It's not.
No, suspended. Now, we are talking about a presidential proclamation where the Constitution has not been able to be worked on the report that the President has presumably got from the Governor, etc. And therefore, there's a presidential proclamation under 356.
No, I specifically drew your attention to this because you said that while referring to the fourth argument of yours, the fourth contention of yours, you use the phrase that in case there is possibility of misuse.
By suspending and then changing the nature of the state.
Please continue the argument.
The suspension becomes like an obliteration. If you suspend a requirement to consult the people of the state and then change that state into a union territory, that suspension it's an obliteration virtually. It might not make any difference whether we call it a suspension or
so,
obliteration.
Singh, are you approaching it from the perspective of Article 356, that the power under Article 356 cannot be used to achieve these ends, such as the suspension? I mean, how are you further exploring the point?
Yes, unless this was in furtherance of the object of 356 and it pertained to a body or authority of the state. Here, the suspension is of a constitutional provision which deals with consultation with the representative body of the state, which is the legislature of the state, the legislative assembly of the state. Now, this can't have even the remotest nexus with an Article 356 object to suspend consultation with the legislature of a state, or even, I'm now arguing against myself, or even the substitute for that legislature, which is parliament, to suspend that consultation altogether, can't have any nexus with the object of 356. 356 is for the purpose of, because the constitution hasn't been working in that state, or the state isn't able to be governed as per the constitution, and therefore there's a temporary suspension. And I don't want to go into repeat arguments on 357.
The argument on your side has been that 356 is for the purpose of restoring democracy, not for abrogating. That was the argument.
That's right. And this, unless the union were to tell your lordship when they start their arguments, whenever they do, unless the union is to tell your lordship that yes, it was an object of Article 356 to change Jammu and Kashmir from a state to a union territory, they can never justify this as having any nexus with the object of 356.
Therefore, there are two distinct arguments, therefore. One, whether the power under Article 3 can at all be utilized to convert a state into a union territory. That's one.
That I'll come to subsequently.
And the second, whether this power was correctly utilized or constitutionally exercised at a time when Article 356 was in operation. Does Article 356 empower the union to do this?
That's right. But
there are two different areas which we would like to hear from you very briefly.
I'm very grateful to my Lord the Chief Justice, but this is one step before that. I'm saying that if you read, it says, make such incidental and consequential provisions as appear to the President to be necessary or desirable for giving effect to the objects of the proclamation, including provisions for suspending in whole or in part the operations of any provisions of this Constitution relating to any body or authority of the state. So my argument here is, one, such the para C2 can never even remotely be for giving effect to the objects of the proclamation. On 18th of December or 19th of December 2018, the object of the proclamation was not for changing the status of Jammu and Kashmir. And if it were, then it's a fraud on the Constitution. It's an absolute fraud on the Constitution if you admit that this had a nexus with your object on 18th of December.
In fact, to stretch your argument could be that the object of any proclamation under Article 356 can only be to ensure that the government of the state is carried on in accordance with the provisions of the Constitution.
As a stepping stone to restore full democracy in that state. I bow to your Lordship. I couldn't have put that better, very neatly. And I am very happy to adopt that line as my own. I'm confining myself to C2. I'm not, others before me have argued on the larger issue, but since I'm on the State Reorganization Act alone, I'm just keeping it as narrow as possible. C2, I submit, is clearly beyond the purview of 356, and except for revealing the underlying intention of that proclamation, it does nothing more.
But Mr. Singh, is the conversion of the state into a union territory, is it severable from the abrogation of 370 itself?
Yes. It is. The two are completely separate. Here, what has happened is that relying on Article 3, they have by passing a simple law, simple parliamentary law under Article 3, a State Reorganization Act was passed. And
So your argument on the conversion of J&K into the two UTs, that would really survive irrespective of the decision on
Yes, yes.
370, abrogation of
my
370.
submission starts with that this is completely independent of the abrogation. Whether J&K was from day one completely under the Constitution of India with no commas and full stops taken out of it, whether it was under 370 as applied to J&K, with any permutation
Even
and
if you were to
combination.
exercise this power, according to you, in relation to any Indian state,
That's right.
this would be unconstitutional.
That's right.
Irrespective of the special considerations which apply to J&K in relation to 370.
Yes. And irrespective of the proviso also, the scheme of part 1 and read with Article 368, and I'll show you, Lordship, it completely precludes such an exercise. Also, when I come to the history, your Lordship will find that all right from the 1919 Government of India Act, 1935 Government of India Act, the precursors to Articles 3, 4 and 368, and then the Constituent Assembly debates, and then what came about, this was never the powers given to the Crown, initially to the Governor General in 1919, to the Crown in 1935, and to the Parliament in 1950, were powers meant to mediate when a minority, perhaps in a state, made out a justifiable case for greater self-representation. Suppose there's a linguistic minority in a state, but they have a distinct area, like Haryana was in Punjab, or Himachal was with merger of princely states. The idea, or let us say there's certain other reasons where there are people who can't get a majority in that state assembly to accept, but they make out a case for greater autonomy, greater representation, for full statehood. Parliament under Article 3 and 4 acts as a mediator. Because
how were the UTs born in the Republic?
I'll come to that.
I think in my judgment in NCT 2, I've dealt with the whole history of how the UTs were created.
You have.
And were the UTs, in other words, was there a peculiar constitutional history attached to the creation of UTs?
Yes.
And does that category remain frozen now?
In fact, that category has moved consistently towards full statehood. By the 4th of August 2019, there were only...
the origin of the creation of UTs?
Yes. But look, may I...
We'll have to then, because your argument will have to explore in this way. What is the history surrounding the creation of union territories under the Indian Constitution? Yes. 2, does that category then remain a sort of frozen category in the sense that you can convert a UT into a state, but you can't do the reverse process? That's the second point.
And that is historically, that is what has happened. So by 4th of August 2019, there were 7 UTs left in India. Delhi, Chandigarh, Daman and Diu, Dadra, Nagar Haveli, Puducherry, Lakshadweep and Andaman. All other UTs were gradually, once they could become viable units, the moment an area could become a viable unit as a state, it was converted into a state.
What do we find? I mean, how were the UTs created?
Yes. So, look, can I just then give your Lordship the pages for this first argument? Just so that...
yes, certainly. And then we can move to the next.
Here, my Lord, Justice Agarwal spoke for the bench. It was a unanimous verdict of the Constitution bench.
And what is the principle which Justice Agarwal has laid down there in para 19?
On the nature of the power under 356 and the nature of the scrutiny, he goes a step further beyond Bomai. The governor takes the oath prescribed by 159 to preserve, protect and defend the Constitution and the laws to the best of his ability. The power under 356 is conditional, the condition being the formation of satisfaction of the President as contemplated by 356(1). My submission is that this applies equally to 356(2). And when the President is satisfied that certain measures need to be taken to fulfill the object of the proclamation, that also must meet the same test.